Hello, everyone, and welcome to day 2 of the Elder Justice Symposium on decision-making capacity. For those who are joining us for the first time today, welcome, and for those who joined us yesterday, welcome back. I don't think I'm alone in saying that yesterday was a phenomenal day, and we covered a tremendous amount of information and topics to kick off the symposium. Charlie Sabatino kicked us off with a number of key principles that governed pretty much throughout the day. For me, at least, there were 2 that really resonated. The first one was the importance of assuming that older adults have capacity unless proven otherwise. I think there are lots of people who automatically assume or make assumptions about older adults, and he conveyed the importance of not making that assumption. The second principle that he raised, which resonated throughout the day as well, was the importance of asking capacity to do what? Capacity isn't a binary question. It's not a yes, no. It depends upon what the legal question is at issue or what the functional question is. And so it's always important to ask that second part of the question, capacity to do what, whenever these issues arise. Jason Karlowich then gave us both a historical and a forward-looking perspective on the aging brain and on capacity assessments, helping us to better understand normal aging and what type of issues could arise later on. He too raised a number of points that resonated throughout the day. And again, for me, there were 2 important takeaways. One was the fact that we can't assume that all older adults have cognitive issues. And even if someone is diagnosed with having a mild cognitive impairment or dementia, that diagnosis in and of itself also is not dispositive and cannot tell us everything about whether or not the older adult has the capacity to do a certain function or do something or make certain types of decisions. The diagnosis alone is simply not enough. The second thing that Jason illuminated was the fact that no single capacity assessment instrument is enough to determine capacity. I think for me, at least, the most powerful example he gave was one where the same instrument was used and 2 individuals got the same score, and yet presented very, very different situations. All of that means that we have to know the instruments, we have to know the limitations, what they show, what they don't show, and deciding sort of how to use that appropriately. The next panel that came on was the clinicians panel, and that too was a fascinating panel that talked about the different types of clinicians and elder justice professionals that could play some role in helping to assess whether or not an individual has capacity. They talked about the importance of looking at the whole picture, not just a diagnosis, that there's lots of information that could come in helping an adjudicator, be it a court or a lawyer, to determine whether or not an individual has or doesn't have capacity. We talked about the types of training and things that people should look for in hiring a clinician to perform some type of capacity assessment. Eric then made a number of points that I thought were very, very powerful. I think he warned us about the dangers of leaps of logic, about the fact that there could be clinicians out there who, either due to a misunderstanding or because they just want to impress, will go beyond what they should be able to opine on reasonably, given their expertise or their instrument that they're using. To that end, I think an important item that came out very early on was the importance of recognizing that there's a very big difference between a clinical assessment and a forensic assessment. These different assessments are in different contexts and ask very, very different questions, and that we can't assume that they're interchangeable. That's why it is essential for lawyers, when working with clinicians, to be very, very clear with the clinician about exactly what is the legal question being asked. What is the question that the judge is going to want to know the answer to, and what is the evidence we're trying to adduce? What is the legal standard? These vary widely by state or even by county. And so it is imperative for the lawyer to do the work to identify for the clinician precisely what is the question being asked and what is the legal standard that they should try to develop the evidence for. At the same time, clinicians also have a role. They have a role in being forthright with the lawyers about what they can and cannot attest to, what the limitations are of the clinical instrument being used or the capacity assessment instrument being used are. Again, there's a lot of room for greater coordination and communication. And I think that came out during the panel discussion. I think another point that the clinicians panel raised, which I thought was very, very powerful, was raised by Laura Mosqueda. And what she said was that it's important to make sure that we do whatever we can to present and let the older adults, when and if they need to do a capacity assessment, to help them be at their best. And what does that mean exactly? That means that making sure to take the time to know them a little bit, to see whether or not there's a chance they might be under or over medicated, whether or not they might perform better during a certain time of day, in the morning or in the afternoon. Taking the time to figure out whether or not there are sensitivities that might affect their ability to present themselves in the best way possible, be it light or noise. All of these things can impact how they perform. And so, as Laura said, we want to do whatever we can, or clinicians should do what they can to restore capacity, to put themselves, allow us to help them put themselves in the best light possible. I know, for example, that my wife will not let me meet anyone or talk to anyone before I've had several cups of coffee during the allergy season to take my medication. The thought of allowing myself to be assessed in a situation before, I've had my coffee or my allergy medication is unthinkable. The thought of allowing someone to have a capacity assessment done when the stakes are so high, when their rights may be deprived, when justice may not be served, when a decision may be made not to pursue an action based on a situation when they are not at their best or not able to perform that way, I think is just criminal. And so I think we as elder justice professionals have a responsibility to be mindful of all those things when and if we need to have someone take a capacity assessment. The last presenter of the day was Nina Cohn, who did, I think, a phenomenal job of presenting both the big picture and the small picture. In terms of the small picture, it's at the end of the day, capacity assessments have costs. There are human costs to having someone subjected to a capacity assessment where, they have to be analyzed and scrutinized. They're scary, they're stressful, and they may not always be necessary. I mean, this goes back to Charlie's point about asking capacity to do what before subjecting someone to a full-blown capacity assessment. It's always important to ask what is the function that's being asked for here? What is the assessment trying to ascertain? Because it may be that we don't need to do the full assessment. There may be certain questions that can be asked more discreetly and get the answer without having to do the full assessment. So anyway, all of these things were brought to bear by Nina. She also talked about sort of how do we advance the field? How do we promote an older adult's autonomy and dignity, as well as the elder justice field, while necessarily dealing with these capacity assessments? We do have a role in both our criminal and civil systems. And she laid out, I think, three very, very important themes, which again, echo themes raised earlier. The first one is to be domain specific, which is just another way of saying what Charlie said about asking capacity to do what. The more precise we are, the more detailed we are about exactly what the question is, the better chance we'll get the right answer and not something that's going to have downstream implications that were unanticipated. The second thing she said was that let's make sure that we're applying the correct legal standard. It is not easy in this day and age, given the fact that the standards may vary widely depending upon what the question is, whether or not someone has testamentary capacity, whether or not they have the ability to make financial decisions. These questions vary widely. The standards vary widely by state and by county. And so it's important that when a lawyer is beginning a process of asking a clinician to help do some sort of assessment, that they are applying the right standard. The last point that Nina made in terms of how we can advance the field and while protecting and preserving the autonomy and dignity of the older adults, is to highlight their abilities as well as their limitations in capacity assessments. Again, these vary widely by jurisdiction in terms of the questionnaire or declaration that has to be completed by the clinician. But just because the form asks for certain things doesn't mean that we should be limited by that. And that I think the trier of fact, be it the court or a jury or whomever, should have the benefit of a holistic picture of the older adult. And make sure that while there are certain limitations that are identified, that we also identify all of their abilities that may ultimately inform it. In fact, it may impact the ultimate adjudication about what is to be done in a particular situation, whether or not a guardianship has to be imposed, whether or not a conservator has to be imposed. Let's look at the whole picture and not simply a slice of it and be bound by that. The last thing I would say is going back to the beginning of yesterday when the Associate Attorney General gave her remarks. She emphasized the importance of greater collaboration and communication among elder justice professionals. We all want to do the right thing, but there are many, many pieces and many cogs in this machine. And it's critical that if we are going to do right by older adults, that we communicate more, collaborate more, understand what one another needs to do our jobs and the limitations of that, and having a little bit of humility there on that front. I think she emphasized that point, and I think that's a point well taken. I think the last thing she emphasized, which I would want to echo, is the fact that this symposium is really just the beginning of the discussion. There was a tremendous amount of information conveyed yesterday, and it's going to be explored today and on Thursday, but it's just the beginning. All the materials that we develop are going to be placed on the symposium page of the Elder Justice website. Communications that we have are going to be hopefully developed and explored further. I think Nina during her discussion raised a number of policy questions, and others raised policy questions as well. We should be talking about this. If there are ways that there are legislative fixes or policy fixes that could be implemented to help us on these issues, we should be pursuing them. And I think it's our hope that the symposium provides a platform for that, a first step in identifying the issues, creating a platform for highlighting these issues and getting to the right people so we can help advance the ball together on that front. Before turning to the panel, I just want to say a quick thanks. As you can imagine, a symposium like this takes a huge number of people, all of our federal partners whose logos you've seen, but in particular, I would just want to highlight our partners at the Administration for Community Living at HHS, CFPB, SEC. I want to thank Karen Wilson and her team at the Office of Legal Education, as well as Candy Wright, the Director of Training for the Civil Division. And last but not least, I want to thank the Elder Justice Initiative for its work, in particular, Shelley Jackson and Naomi Karp. They were the true architects of this symposium and thoughtfully and carefully and lovingly followed through and planned every single detail of the symposium that we're experiencing today. So thank you to all of you guys. And with that, I'd like to shift gears to the criminal panel. Yesterday, during the discussion, we talked about the different ways that capacity assessments could play a role in both civil and criminal matters. Today's panel will focus on the role that capacity-related issues may play in criminal proceedings. Let me say at the outset that we know that the issues that we're raising here affect a wide array of scenarios and persons, including persons with disabilities. But for today's purpose, we are focusing pretty narrowly on the role that decision-making, capacity assessments, and issues arise in connection with older adults in criminal matters and criminal proceedings. Before introducing the panel, I just want to say, like, why are we even talking about decision-making capacity in the criminal setting? And that's because in a number of different criminal-related matters, it boils down to the question of consent, whether or not the older adult could and did consent to give away his or her wealth, or decided to forego some type of health treatment. And so in analyzing whether or not the individual had consented to the key act, oftentimes it boils down to a question of whether or not they had the capacity. Now, capacity may be vitiated, or consent can be vitiated by a number of different factors. There could be undue influence, there could be coercion, and there could be diminished or lack of capacity. We will be focusing on the last of those and how that plays out. We're going to be using two different scenarios that are sadly altogether common. These are composites of scenarios that every single person on this panel has experienced or in their professional work. And so we put these together as ones that we hope are and do capture experiences of those participants in this symposium. And we'll be talking about those two different scenarios. They were sent out with your materials. They're also available on the Elder Justice website symposium page, and I'll be reading them as well for those who weren't able to pull those up. So before turning to the scenarios, I'd like to take this opportunity to welcome our panelists and let each one of them introduce themselves. So first off, Michelle, could you please introduce yourself? Tell us a little bit about what you do and how capacity plays a role in your responsibilities and job.
Sure. Thank you, Andy. My name is Michelle Gayette, and I'm the Assistant Director for North Dakota Department of Human Services Adult and Aging Services Division. And in that role, I oversee the Vulnerable Adult Protective Services in the state of North Dakota. When I'm thinking about your last question, how do capacity issues arise? I think, studies have shown APS caseworkers and or some law enforcement officers are sometimes the first people to encounter a situation where an older person or a person with a disability has been the victim of abuse, neglect, or exploitation, and they may also have experienced impaired decision making. So then these issues start to become important as we progress through our case and we're investigating that abuse, neglect, or exploitation. And then through our work with tools, the assessments of the fact and the environment, and then any further testing, we're helping to determine if the person fully understood the risks and the decisions they were making. So the consent that you talked about just a little bit ago, Andy. Thank you.
Great, thank you. Skip, could you introduce yourself?
Yes, my name is Skip Swain. I'm a detective with the Fresno County Sheriff's Office in Fresno, California, and I am assigned and have been assigned for a little over 11 years of my 30-year career to investigation of elder abuse and dependence here in Fresno County. So I investigate physical abuse, financial abuse, caregiver neglect, and suspicious elder deaths here in Fresno. And oftentimes capacity is at issue, whether or not someone can make the decision that they're making, whether it is unduly influenced, whether they have the capacity to make that decision, or if they have the capacity, is it just a bad decision? But oftentimes it takes a lot of investigation to figure out where we're at with that.
Great, thank you. Jane, could you introduce yourself?
Thanks, Sandy, and hi, everyone. So my name is Jane Walsh. I'm a Chief Deputy in the Denver District Attorney's Office, and I head up the Elder and At-Risk unit here. And for the last 10 years of my legal career, I've been working exclusively in the area of elder and at-risk cases. And I think capacity and generally cognitive status comes up at multiple points in my job. It comes up even pre-filing, during the investigation. Sometimes the perpetrator will raise the cognitive capacity of the victim to cast doubt on their credibility, even at the first moment that police arrive. Then at the filing stage, of course, all of us as prosecutors we're reviewing the strength of our case. We're also looking at credibility issues at that point. And then capacity is a ball that's in the air because we may have victims who are very elderly and we need to be keeping an eye on where things are at on the way to trial. So I guess I find it ironic that people they're exploited because of vulnerability, and then it might be that vulnerability that stops folks in our job from feeling that they can move forward with these charges. So it is a big issue, and I'm very glad that we're talking about it today.
Great. Thank you, Jane. Candace?
Good morning. Hello, Andy and
Hello.
other panel members. My name is Candace Heisler, and I'm speaking to you from the Bay Area of San Francisco. And my background is as a retired assistant district attorney for San Francisco. I served in that position for more than 25 years and handled both domestic violence and elder abuse cases for about 10 of those years. Since I retired, I've spent most of my time training, writing, and consulting on a variety of subjects relating to elder abuse, abuse in later life, and domestic violence. And I train through that work a variety of professionals, many of whom are on our panel today, but including adult protective services, prosecutors, law enforcement, judges, and a variety of other kinds of professionals. I think today I'm primarily wearing my trainer hat and not my former hat as an assistant district attorney. And when I think about capacity and the different ways it arises in training, it's helping a variety of professionals to understand things like how does determinations of capacity inform investigations and case building? And that really cuts across many disciplines. How do we distinguish and think about capacity? And I'll reiterate, capacity for what purpose against competency or testimonial capacity, because there's a lot of confusion. We also need to help people understand the role of dementia and its impact on decisional capacity and how that impact affects prosecutions, investigations, and interventions. And finally, just to pick a few things, understanding the difference between screening and assessing for capacity, and how one screening really shouldn't be over-relied upon to help you figure out what's the future trajectory of a case or an investigation. And I'll look forward to talking a little more about those as we progress this morning.
Great. Thank you. Judge Young?
Hi, excuse me. I am Judge Young, or Mindy Young, and I am a King County Superior Court judge in Seattle, Washington, which is our trial court out here. I've been a judge for the last 3 years, but really more pertinent to our discussion here today. Before that, I worked at the King County Prosecutor's Office, and 10 years of that work included overseeing our complex fraud division, which included a specialty unit of that was focused on elder fraud, financial exploitation, and neglect. And so I handled those cases directly, as well as oversaw any case that our office, or that office, no longer my office, filed at the time. And clearly, as everybody's already said, capacity was very much at issue in many of those cases that needed to be evaluated and addressed. As a judge, it's a lot more interesting in the sense that I don't know what I don't know, and that I am reliant upon all the other players to provide me with the information to know whether or not it's an issue and then what the issues are. I certainly can ask questions, but I don't have the opportunity to go out and do investigations. So it is every bit as important for me to know about those different testings that there are available and the different tools to be able to turn capacity to be able to make the decisions that I have to make, which is typically as a gatekeeper to determine what cases go forward and what evidence gets presented.
Great. Thank you, Judge Young. And last but not least, Randy?
Hi, my name is Randy Otto. I'm a psychologist by training. And the focus of my work is assessment of people who are involved in the legal process, including individuals for whom questions about their capacity to exercise various kinds of rights has been raised as an issue. I'm a faculty member at the University of South Florida here in sunny Tampa. And in addition to some of my work, my academic work that goes on considerations when it comes to assessment of decision-making capacity, I actually roll up my sleeves and get involved in evaluating people who are involved in such proceedings. So thank you.
Great. Thank you, Randy. Okay. So just to orient us a little bit before we dive in, we've selected two case scenarios, one focusing on elder financial exploitation, and another focusing on caregiver neglect. After our panel discussion, we've reserved a few minutes at the end for questions. But one of the points I want to raise before we dive in is one that Jane touched upon, which is in contrast to the discussion tomorrow in the civil panel, where capacity is determinative of or may impact whether or not someone's rights are taken away, for example, in a guardianship sort of context. The criminal context is a little bit different. And as Nina mentioned yesterday, one of the roles of capacity assessments is that it may impact whether or not justice is actually served, whether or not someone's rights are vindicated, whether or not a criminal action is taken, whether or not a criminal investigation has even begun. And so the reason why we have put together a panel that's multidisciplinary in nature is because we hope to show all the steps along the way where false assumptions or misunderstandings about capacity could impact whether or not a criminal action is ultimately taken against a perpetrator of a potential case of caregiver neglect or elder financial exploitation. And so these composite case scenarios were meant to sort of illustrate all the different ways it could play out. So with that, I'd like to turn to our first case scenario, which I'm going to read out. And again, to the extent that you'd like to read along, it is in the materials that were sent to you or on the Elder Justice website. Here we go. Mr. Kinney is a 72-year-old male. He lost his wife 2 years ago and has been lonely, although he has 3 children, one of whom, Karen, lives nearby and visits frequently. They have a congenial, albeit superficial relationship. Although about 6 months ago, Mr. McKinney ran into a 28-year-old woman, Stacy, with her daughter at church. Mr. McKinney began to see Stacy socially more and more frequently. Stacy moved into Mr. McKinney's home 2 months after they met. He was pleased for the company. He was happy to provide for Stacy and her daughter Miranda. He loved them both. A few months ago, Karen the daughter, stopped by to bring her dad his favorite milkshake. She noticed that it looked like someone else was living in the home. Karen asked her dad about it, and he replied matter-of-factly that Stacy and Miranda were living with him. Karen told her siblings about the new living arrangement. They were not pleased, but decided it was his life. About a month later, Karen stopped by the house, and she happened to see Mr. McKinney's credit card statement on the table. There were numerous large charges at women's clothing stores, jewelry stores, and toy stores. It looked like his credit card was maxed out, causing Karen great concern, but she didn't say anything to her father. Karen stopped by again about a month later. Her dad's next-door neighbor was doing some yard work and waved Karen over. The neighbor told Karen that her dad had stopped having lunch with him. They had been neighbors for the past decade, and almost every Friday they would have lunch together, but now Mr. McKinney refused his invitations and barely spoke to him. The neighbor asked Karen if there was anything he should know about. He was worried about Mr. McKinney. Karen talked to her siblings, and they decided they had to find out what was going on. One time when Karen stopped by to see her dad, Stacy was out shopping with her daughter, and Karen decided to confront her father. In talking with her dad, looking through his financial papers, and visiting the bank with her father, Mr. McKinney reluctantly divulged that over the past 6 months, in addition to credit card debt, he was currently in arrears on his property taxes and had taken out an $80,000 mortgage on his home that he had owned outright. Although Mr. McKinney shared all of his financial information with Karen, he was defensive, reiterated that he loved Stacy and she could have anything he owned as far as he was concerned. In discussing all of this with her siblings, the family didn't know what to do and decided that Karen should contact APS. At issue is whether Mr. McKinney is a victim of a crime of financial exploitation of an elder. At first glance, it appears that Mr. McKinney has consented to these financial transactions. However, there are several actions, as we talked about before, that may negate whether or not he could have consented to these financial transactions, including undue influence, fraud, and perhaps not lacking the capacity to make these decisions and consent to the transactions. So with that, let's start at the beginning. And with you, Michelle, let's say APS receives this report. Tell us what APS would do in this situation, what it can and cannot do in this situation.
Sure. So I would probably want to start out with noting that each state has a different definition of who Adult Protective Services or APS serves. And so participants would want to make sure that they're noting what the definition of in North Dakota, a vulnerable adult or dependent adult, as we've heard others say. So our intake would receive that report. They would review the information that was provided, and then they would make a determination on screening that report in or out, meaning if it was screened out, can they offer other services? If it was screened in, then it meets the definition for an investigation. I checked with other states before doing this, so I could make sure that I was speaking clearly to not just North Dakota, but to other states as well. And there are quite a few states that are looking for a substantial mental or functional impairment that would inhibit their ability, making them meet the definition, the person, Mr. McKinney, of a vulnerable adult. But for the purposes of this discussion, we'll assume he meets that definition and the report is screened in for an investigation. And so what APS investigators would do would be to look to gather collateral information prior to the visit, if they can find that information. And then best practice would be an unannounced home visit to see the environment as it actually is, and to get the eyes on that situation. They're looking at risks, including the environment. What are some of the support systems? What is the neighborhood? What is home like? And then looking for changes in behavior. And then, as all services are voluntary, and we have no indication at this point right now that there's any decision-making capacity concerns, we would make referrals as appropriate and in line with his wishes, keeping in mind that he could refuse the services that are offered, but we want to work with him and make sure that we're meeting his wishes and desires.
Okay. Given the facts in this situation, would you recommend doing a some type of decision-making capacity assessment? And if so, what would you do? And what instrument would you guys typically use?
Sure. So I think as best practice, it would be important to do that as we're looking forward and exploring all avenues of the case. So we want to help to determine if that exploitation has occurred and what were his level of abilities, his understanding of the risks, his decision-making. So in North Dakota, we were recently trained on using the mini cog, but other states may use something like the SLUMS. You might use the Montreal cognitive assessment. I know that the presenter yesterday talked about the mini mental status exam, but every state has kind of a different tool that they use, but we want to keep in mind these are tools, right? So APS is using this as a tool to inform next steps. We want to make sure that if there are concerns noted in that testing, the brief cognitive testing that we've done, we would want to make another referral for further testing and or diagnosis. We do not diagnose with APS. Doing a mini cog or some form of test in the field may also help us to determine if we believe that he may have decision-making capacity in certain areas and can accept or refuse those services. We then want to look at creating a service plan with him, always keeping in mind we're going to respect his wishes and looking for the least restrictive options first.
And so would there be any circumstance, or what are the circumstances where you would refer Mr. McKinney for a full capacity assessment? Like, what would you look for? Under what types of circumstances would you make that referral?
Sure. So if we had done the brief testing out in the field and we noted some concerns based on the scores and the training that we've had to do them here in North Dakota, that would help us to inform whether or not we should do further testing. So if we saw the scores were lower and based on how those scores fall out, we would make a referral for the further testing, including the formal cognitive testing.
One quick question for you on that. Yesterday, if you recall, Jason had highlighted an example, which I referred to earlier, where two individuals got the same score, but there were different issues. Do you also look at the underlying data underneath the scores, or do you just sort of take a look at the score and say, oh, automatically, if it's below a certain amount, we refer someone for a full assessment, or do you look at it and see whether or not there could be nuances there?
That's a great question. And I would say best practice is to look at all aspects of it, right? All nuances to make sure that we're not, as you said, right, burdening the person or doing invasive testing that's maybe not needed.
Great. And here's the last question here is like, under the circumstances we just laid out, would you make a referral to law enforcement?
Well, for the purposes of this, Andy, we'll say that there were scores and we had the nuances. We would make a referral, and we would want to share things like, what did we see out in the field? Where were some of the concerns that that we noted when we were out there, like the risks? What was the basis of the initial referral, which was that financial piece, and anything else that we can share to help that further the tester to see what avenues need to be explored. And I really liked what you were saying and what they said yesterday is the capacity to do what. And really in this one, we're talking about financial exploitation, right? So managing finances. So that might want to be something that we would inform that doctor to look further into. Does he have that decision-making capacity for financial purposes?
Great, thank you very much. Oh, just in case I just missed it, in addition to talking with people that you mentioned before and gathering that type of evidence, would you also, as a practical matter, of course, talk with Mr. McKinney's physician?
That's I think is best practice for us too, is to try to get that information as part of our collateral information gathering. Absolutely.
Okay, great. Okay, so Skip, turning to you now. APS has gathered this information. I know that things work a little bit differently in your jurisdiction, given that APS doesn't assess decision-making capacity. But let's say they sent over the report and everything that Michelle just mentioned. The interviews, the initial report, perhaps interview notes from the doctor, any type of assessment that they've done. What would you do with that information? What's next?
Well, I'm lucky enough to work in with APS, and I'm housed with Adult Protective Services here. So it's easy for me to staff a case, get the reports. Also, we have public health nurses assigned to Adult Protective Services. Oftentimes, they will take one of the public health nurses out with them in the field for an initial assessment, and the public health nurse will give some sort of a cognitive screening tool, use some sort of a cognitive screening tool for a case like this. For me, though, I want to look at everything. If I have medical records, I'd like to look at them. If I have, I want to talk to the family members. I want to know the history of Stacy. What's her history? What's her source of income? What was, what was his history like for his financial affairs? Was he always having problems managing his finances, or is this something of late? Is there possibly some undue influence going on? I would want to speak with him directly, one-on-one, without Stacy in the home, so there's no chance of her influencing what he is going to say to me. And just because he has or appears to have capacity doesn't mean that he may not have some frontal lobe dementia or something else going on that is clouding his decision making, or that he's got or that he has his capacity is of such that he's not being unduly influenced. So I may suggest further testing. I may suggest neurology testing on something like this. And also, I'm looking at a misuse of power of attorney, most likely in a case like this. And I want to know what he is aware of and what he is not aware of. He may not be aware of any of this. Stacy may be handling his finances because that's one less thing that he has to deal with. So I say this, where there's smoke, there's fire, or it's a barbecue, but oftentimes just from outside, we can't tell. We have to open that gate, go into the backyard, and figure out whether we have an emergency or we don't. In this case, there is plenty of smoke, and most likely there is fire. And hopefully we can, stop the money from flying out the windows and see what is going on, and if it rises to criminal action.
Well, let me push on that a little bit, Skip. I will say that we talk to law enforcement all across the country, and this is a very, very common scenario. And it is not uncommon, I think, to be absolutely blunt about it, that there may be instances where a police officer who gets an allegation like this, where the gentleman does not have any other type of, facially apparent problems or issues, he can make his own decisions. It's just it's a family affair. It's his own matter, and it's easy to just walk away. Why is it that in your jurisdiction that's not good enough, that you want to delve deeper into it and get a sense of the bigger picture?
Well, I think that we're pretty involved as investigators with our uniforms. We have some tools out there. We train our guys, and if it just doesn't pass the smell test, I mean, there are a lot of people that say, well, this is his decision to make and he can make that decision. Well, that's possibly true, but let's make sure that that is in fact the case, and that we're not missing something, so that we don't we don't miss that exploitation of our elders.
Okay, great. Thank you, Skip. Okay, shifting gears again to Jane. Skip has followed up. He's done additional investigative work, gathered financial documents. Given these fact patterns, at first blush, would you take the case? Would you decline it? What would you do, Jane?
So first, I'd be very glad to have someone with Skip's level of experience on this case, and I want us to get together as soon as possible. One of the things that I believe would make a difference, Andy, in terms of, do these cases go forward, is that mandatory reporting certainly in our state would mean that law enforcement and our DA's office and Adult Protective Services would all receive that report within 24 hours. And I think that, as Eric said yesterday, he talked about seeing scores of these undue influence cases. There are some red flags and pattern features to this case that would really raise alarm bells. And I think all of our agencies would be taking a good look at what's going on. So yes, I would accept it, but I would only accept it for further investigation at this point. And I do think, as Skip says, that there's a lot more flushing out of what is exactly going on in this situation. And a very important feature is really respecting the fact that apparently, Mr. McKinney's very lonely. He's a widower. He's started this new relationship that's super important to him. He's probably feeling very threatened right now by Adult Protective Services and now law enforcement getting involved. And to what extent is Mr. McKinney prepared to work with us? And what's his feeling about just proceeding with the matter and even talking to us more? I guess it would be great if Adult Protective Services had screened this in and we already had a lot more detail, but frankly, that might not be the case. And we may have a situation where our victim he's declaring his love for the suspect. He may not be willing to cooperate, and I guess we're hoping that we can use some leverage, some relationship to really get into this situation. So we have this sudden new relationship. She's moved in, so she is in a prime position to be exerting influence over him. We don't know what she's saying about his family members. We're seeing this change in his pattern, his relationship with his neighbor, which is so concerning, that these long established patterns are changing. As Skip said, we want to know what his entire financial situation is and what has been going on prior to this. And is all of this spending for the benefit of Stacey and Miranda? Is some of it for himself? Is he a generous person? Does he have a lot of money? So I'd also want to know, because it's not clear to me from the case scenario, is this a romantic relationship, or is this a kind of father-daughter relationship where Stacey may be calling herself his adopted daughter and portraying Miranda as his granddaughter, and kind of building these quasi-familial relationships that we see a lot in these undue influence cases? So I think his capacity may be in the mix, but I think we have to respect and presume that he has capacity at this point. So in terms of what would we need to go forward, Andy, if I can also cover that, you know, prosecutors have this kind of Tetris effect of, you know, cases are coming down all the time. So I think it's helpful for us as prosecutors to think about the structure of the case that we're going to build. And from Skip's point of view, I would hope to sit down with Skip and check that none of the expenditure that we're hearing about was unknown to Mr. McKinney. So there was no theft involved there, nothing unauthorized. It was all with his consent, so that we can really identify, step one, identify if this is going ahead, it's going ahead as an exploitation case. And then I look at three bins of as Jason Kowalish was saying yesterday about bins, buckets, call them what you will. I look at three aspects of the case that I want law enforcement to identify and to develop as we go forward. So I want to see them look into the suspect exploitative conduct. And that's often, I feel, overlooked a little bit in terms of kind of putting in the foreground the victim in their capacity. We want to see what are the instances of deception and influence that we can find out about. We need the money trail. As Skip said, we need the suspect history. We need to know whether this is something that Stacey has done before. We need to know if she's doing any other things in the background. Are there any moves to make a new will or to get a durable power of attorney? Are there any other instances of isolation that we can pin, we can stick a pin in as showing this pattern more clearly? And also, we need to look at the victim vulnerability, and I think the primary feature to me right off the bat is the loneliness. And so I think we need to know more from the family, as Skip said, really to flush out the victim's history. And then thirdly, I think we need to have that third bucket, which is really, it's all the collateral evidence, it's the context, it's the buddies that perhaps he would go to lunch with, he would go for breakfast at McDonald's on a Sunday with, that he would go to his church friends. We know he's a member of the church, which is where he met Stacey. That is a mine of information for us to get. And really, there's so much to explore here, and I'll cut off but I think we need a structure to the case. I think we need to pay attention to all these aspects of the case and build the exploitation case from the outside.
Let's throw an additional fact into the scenario. Let's say that Skip has interviewed and met with Mr. McKinney, as he said he did. Let's say that Skip tells you that Mr. McKinney, when he met with him, was forgetful, confused as to exactly what was going on or what was involved. He appears disheveled and was emotional at times. You've had a chance to interview the video of this interview. And it seems that there are times when Mr. McKinney is struggling. Let's say you have made a decision that you want to have an evaluation done of Mr. McKinney. Can you tell us a little bit about what that process looks like?
Absolutely. So firstly, we would have Skip or Adult Protective Services talk to Mr. McKinney about what an evaluation might involve and really find out whether he's prepared to go ahead with it. We would take steps to organize that and to arrange for transportation for him if he's willing to do that. I think that in these cases there may be an agency that is in the, as it were, in the lead, or alternatively the family may be kind of coming into the picture more strongly. We would try to really try to get an assurance from Mr. McKinney that this was something that he was okay with, because I think that many of our victims just will tell us to pound sand. They do not want to have their capacity assessed. You know, we're talking about these assessments. We may have to think about a different structure to the case, a way to build the case, because our victim just says, no, I'm not prepared to do that. So unless there's some kind of order in place in other proceedings mandating some kind of evaluation, then from a criminal point of view, we're not going to do it. But if we do it, we're going to look for someone who can see him quickly. We'd like to have someone who's experienced in criminal proceedings, and we'd like to do that with full cooperation and consent.
Again, assuming that Mr. McKinney were to consent to the capacity assessment and that you were to make a referral for an evaluation to someone, in line with the discussion yesterday, like, let's say you're working with someone new, not an experienced person, like, what is the question that you ask of the evaluator? Like, what would you say to him or her? And, you know, just sorry to put you on the spot like this, Jane, but like, at a really granular level, what would you say to the person? Like, I want you to find out what in this situation. What would you tell him or her?
No, that's a great question. And I think it really varies from case to case. So right now in the hot housing market, for instance, we might get a lot of cases that involve some particular transactional situation very recently. And we might be homing in to ask the evaluator very much to look at their capacity to contract, their capacity to manage their finances. That would not always be the case for me. If we had a long type of exploitation case that had been going on and it had covered multiple different acts, I might be asking them a more general, for a more general view of Mr. McKinney's cognitive functioning. So I might be asking them to, can you please assess his cognitive functioning? Can you identify areas of impairment? If yes, if you're identifying impairment, how would that affect his functioning? Does he have insight into that? Does his impairment make him vulnerable to influence from a third party? So I would be asking for, I think as Charlie Sabatino said, you know, that big picture assessment, I think is really important because it's not just a binary question. It's not just a yes/no question in many of these exploitation cases. What we want to know is we really want to know about the nuances and the intermittencies. We want a good picture of how this person is functioning on a number of different levels.
Great, thank you, Jane. Candy, turning to you, as a trainer of prosecutors, what would you tell a prosecutor, a class of prosecutors, when confronted with a case like this? What should they look for? Jane obviously has highlighted a number of things that she would look for as a prosecutor, and Skip has highlighted sort of what he would look for. But again, let's lift the lens a little bit. As a trainer of prosecutors, what would you tell them about a situation like this? And I think you're on mute, or at least I can't hear you.
Good reminder. Thank you.
Sure.
So for context, when I'm teaching prosecutors about competency and capacity, I'm not doing it alone. And I think it's important to acknowledge that my co-presenter is someone with extensive experience, usually a geropsychologist or a geropsychiatrist. This is a person who not only understands geriatrics, but has many experiences conducting assessments, whether they're along the lines of the way Jane has laid it out or addressing other kinds of issues that arise in a criminal case. And I can't undervalue and not highlight the importance of having the benefit of that co-teaching perspective. One focused more on the medical side, one thinking about the legal side, and then figuring out how they intersect and how they best work together. But Jane has alluded, and so has Skip, to some of the topics that we have to talk about. One is understanding that capacity is not amorphous. It's not an all of the same, but it's really the question of what capacity are we talking about? Is it capacity to do one thing, or is it another? And understanding that legal standards are going to vary according to what the question is. In addition, that we need to recognize that many of our victims will not represent as having capacity issues. And so we need to bring our regular skill set that we use in other kinds of cases to answering the question, do I have sufficient evidence to go forward? If there are cases, and we see perhaps more than many in this world of elder independent adult abuse, are there questions because of the state of evidence or information that we're receiving that may raise questions about capacity and whether there may be impairments, we need to highlight that simply being told that a person has been diagnosed with mild cognitive impairment or dementia really doesn't answer the question, can we proceed? Nor does it answer the question, can this person give consent to gifting property, entering into a contract, or the other. So it's a broader picture. We also need to think about how does, and Jane really highlighted this, how does whatever medical condition is going on impact function? Because that's really the heart and soul of the case that we're going to need to prove if it's going to be based on impaired.
No. Do I need a coat? No, I don't need a coat.
No.
Okay.
Are you walking at a good pace?
I apologize. I've had to mute all. Again, I'm just going to ask participants if you please make sure your microphone is muted. And I apologize, Candace, I'm going to go ahead and unmute you if you'll please continue.
Decisions based solely on being told that a person has a diagnosis. We also want to be cautious because a person with very good social skills, high education and the like can really be deceiving in a short visit and appear to be much more able and have much more decisional capacity than in fact testing or a longer conversation will reveal. We need to think about those screening tools and recognizing what they can tell us, but certainly not basing a decision to proceed or not proceed based only on a score on a test, a screening test. And then never forgetting that for many of our situations where we're going to base a prosecution on a person's incapacity, that we have to establish that the defendant knew or should have known of the existence of that impairment. So that's a quick overview of how we talk about this subject with prosecutors.
A quick overview that could have easily been a week-long training session, so thank you for that. Randy, I'm shifting you to the hot seat now. Yesterday, during the clinicians panel, there was a brief discussion about what lawyers, be they prosecutors or civil lawyers, what should they look for in terms of the qualifications of someone being asked to evaluate or to do some type of decision-making capacity assessment. Could you share your views on what lawyers should be looking for in terms of qualifications in an evaluator?
Yeah. Thank you, Andy. I want to preface my comments by saying, as much as I wanted to be there yesterday, I was unable to attend because of prior commitments. So please forgive me if I'm redundant, and if I am redundant, please chalk that up to reinforced learning. So the one thing I want to avoid, and I don't know the degree to which this occurred yesterday, is I want to avoid what I call discipline boards, that my discipline's better than yours. So I'm not going to talk about the title or the particular license that the professional should hold, but I'll talk more conceptually about what the professional should know and to be able to do. At a minimum, they should be licensed for sure to do whatever it is they're doing, and they should demonstrate competence. And I fear that I'll sound like a broken record in terms of sort of your highlights from yesterday and what other people have been referencing. But I would encourage lawyers to assess kind of the prospective examiner's experience in this area and their understanding of a variety of things. I think the examiner has to have an understanding of normal aging and what that looks like, and aging that can go awry and the kinds of impairments that people are more vulnerable to and how that can affect their adjustment and functioning as well. Many of the things that have already been said are important for that examiner to know. That to describe someone's decision making as impaired requires identification of some kind of impairment. And that might seem like it goes without saying, But what we have to get away from, and you certainly don't want an examiner who's going to draw conclusions about the adequacy of someone's decision-making simply based on the decision made. And one of the things that I repeatedly stress that is, if you're trying to get to whether someone's decision-making abilities are compromised in some way by some kind of underlying impairment, the inquiry should be much more focused on the decision-making and the reasons than the decision itself, right? That's what's important to understand. I was reading in this area a few years ago, and I loved a comment that a neuropsychologist wrote. And he said, tests are not capacimeters. No tests are capacimeters. And that's essentially what most people have been saying, right? In fact, none of the tests, none of the screening tools that have been mentioned in this training in any way get to capacity. They get to they get to cognitive functionings in some cases, which if impaired can affect decision making. But the St. Louis tool, the MOCA, the mini mental state, none of those tools really get to decision making. And if decision making is impaired by some kind of underlying disorder, they're most helpful with respect to grossly identifying people who might be experiencing some kind of impairments, but they don't get you to the quality of the decision making. I would hope that someone who does this work understands, as many people have said, that decision-making capacity is complex and focused. Capacity to make one set of decisions doesn't necessarily reflect capacity to make another set of decisions in another arena. And I want to say this, I've been doing work with lawyers and judges for in excess of 30 years now. And I'm surprised at how few attorneys who contemplate hiring me, how aggressively they vet me. Set up a Zoom meeting, talk with the potential examiner about her experience, ask for a sample of the examiner's work that includes de-identified examinees, right? Send me a report that you authored summarizing an evaluation so I can get an understanding. Identify 2 or 3 attorneys for whom you've done work in this area who you believe would speak positively about you. Now, maybe that actually goes on without my knowledge, but I don't think so. But I would like to see, based on my perspective as the provider of these evaluations, I'd like to encourage attorneys to be more assertive with respect to investigating what the potential examiner has to offer with respect to knowledge base and has to offer with respect to experience. Now you're muted.
Andy, you muted.
I was just to say, I took lots of notes on that. But let me now ask you sort of the tough question then. You're presented with these facts regarding Mr. McKinney. I think folks will want to know, how do you analyze? Would you assess whether or not this was simply an instance of Mr. McKinney making a bad decision or one where he may have had diminished capacity? How do you make that determination between going down path 1 or path 2?
Okay, couple points. One is, to reiterate what I offered earlier, is there is by definition no impaired decision-making without the presence of underlying impairment. So I think that is critical here. I have to conduct an evaluation that gives me insight into whether Mr. McKinney is experiencing any kind of impairment in his emotional, behavioral, or cognitive functioning. If I find no impairment in his emotional, behavioral, cognitive functioning, and I'm convinced that it is a thorough, competent, complete evaluation, I think by definition there is no impaired decision-making. But
wait, stop. Sorry, go ahead. Go ahead. Randy, please.
But everyone in this training agrees that simple presence of impairment doesn't reflect impaired decision making. So what do I need to do now? I need to get a handle on indicators of possible impaired decision making. So I'm going to meet with Mr. McKinney for sure, but I'm not going to simply rely on what Mr. McKinney tells me or any tests that Mr. McKinney completes. I've got to go heavy on collateral data, because that kind of information can, among other things, give you insight into Mr. McKinney's functioning over time and across different contexts. So I do want to talk to his children. You know, in fact, I think I want to talk to the young woman who moved in with him. This is going to be complicated, right? Because it's a criminal proceeding. She's a potential defendant. So I'm going to have to consult with Jane on this issue as to whether I'm permitted to at least reach out to the potential defendant in this criminal matter, but she could give me insight into his functioning. The protective service staff that interviewed him, Skip interviewed him. I want to see the video recording. I want to get Skip's perceptions. I'm not prosecuting the case for sure, but all of these databases can give me insight into Mr. McKinney's functioning across circumstances and over time. But certainly critical to the evaluation is interacting with Mr. McKinney as well and understanding his decision making, with a focus being on the underlying reasoning and not the decisions he made.
Thank you. That's incredibly helpful. What about undue influence? How do you analyze for whether or not Mr. McKinney may have been unduly?
I've had great amounts of experience with undue influence in the civil arena, considerably less in the criminal arena. And I would certainly look to the prosecutor who hired me in this case for some direction. This is what I'll say quickly. Undue influence is a tough nut to crack, because undue influence is really what you're alleging is an interaction between two or more people. In this case, Mr. McKinney and the young woman who moved in with him. When it comes to undue influence as it goes to Mr. McKinney, what I'm probably looking for is impairments that might increase his vulnerability to undue influence. And sort of, I already knocked that out. I've already knocked that issue out with respect to assessing for underlying impairments as it might get to impaired decision-making capacity. But the other half of undue influence is activities in which this third party, the young woman in this case, perhaps has engaged in. So, for example, has she made attempts to isolate him from other important people in his life? Well, the neighbor might have something to say about that. And I'll probably want to talk to Mr. McKinney a little bit about why those regular lunches have stopped. Has the young woman in this case, has she done anything to misrepresent to Mr. McKinney his current situation, fostering dependence, deceiving him with respect to the interests and concerns of his children, and things like that? I've never had an undue influence case where the alleged perpetrator said, "You're right, you got me." I've been engaged in a campaign of distortion and one to encourage dependency. So oftentimes undue influence is by inference. And so what I'm going to be primarily looking for are the hallmark indicators of undue influence. And to the degree I can, look for evidence of some efforts that have been made. Again, I'd like to talk to Stacy, but I'm not so sure that I'm going to be able to, particularly since this is a criminal proceeding. And I think that she's going to be, I think if she has good counsel, she'll be very reluctant to answer my questions.
Thank you, Randy. Shifting our discussion a little bit more to you, Judge Young. Let's say that Jane brings forward this indictment and indicts the defendant for financial exploitation. What is your role in terms, you mentioned gatekeeping, but what is your role in terms of assessing the capacity or the admissibility of the evaluator's testimony? Like, what do you do to evaluate all of that?
So I would come in obviously when everybody else here on this panel has done their work and really fleshed out this scenario in sort of assumptive ways, that there is likely some capacity issues, some undue influence, all of those types of things. And my role as a gatekeeper would come up in a variety of different ways, initially for evidentiary sufficiency. So in Washington, judges review any charges that prosecutors file for evidentiary sufficiency. So it needs to be spelled out very clearly, all of the questions that I'm seeing in the chat and all of the questions that we've explored here regarding, is there an evaluation? Has he refused the evaluation? History of this particular victim, Mr. McKinney, the interviews that have occurred, whether or not there's been confusion. And it really needs to be spelled out as if the judge, I would suggest, is a juror in your ultimate case. You cannot assume that the judge is going to understand these capacity issues. I am a judge who does understand them and can make certain leaps with it, but most judges are not going to have a lot of this background, are not going to have this type of sort of in-depth training and experience. And so it needs to be spelled out what these different tests are, what these different tests mean, and how that plays into Mr. McKinney. All of the issues that a lot of people here at the symposium have with law enforcement or family, not understanding that Mr. McKinney may not truly be consenting or not capable of consenting, will come to play when you're dealing with judicial officers as well. So the evidentiary sufficiency will come up when charges are filed. It can also come up in a whole variety of other contexts as the case sort of proceeds through. In Washington, defense attorneys can bring a motion to dismiss for a lack of evidentiary sufficiency, saying, look, even if I accept everything that the prosecutor is saying, it's not sufficient to go to a jury in the case. And so it can come up in that case. And you still, again, need to be sure that you have spelled out your entire theory of the case and the way in which you would present it to the jury. It can come up even if there's a plea, a guilty plea. There have to be facts sufficient to accept that plea. So you need to make sure that you've spelled that out in the same sort of ways. And then, of course, the final way it can really come up is even after you've proceeded to trial, at the conclusion of the state's case, if the evidence is not sufficient for a reasonable juror to convict, then the case can be dismissed at that point. So you need to be sure that the case as it's come out has come out in the way in which you expect it to come out, or you can end up losing your case after the presentation of your evidence.
Let me put you on the spot a little bit, Judge Young. You heard yesterday one of the presenters, Eric, was talking about these leaps of logic and the dangers of clinicians or experts going too far, one step too far beyond sort of what they can reasonably sort of testify to. In your experience as a judge, or maybe even as a prosecutor, did you see that often? Did you ever see an instance where an expert was just going one step too far in terms of trying to opine regarding an individual's capacity, either for plaintiffs or the defendant, either way?
Yeah, absolutely. I mean, we do. That is obviously a very fraught area for experts to get in, and good opposing counsel will be able to exploit a leap of logic like that. But I don't know that. So there's two types of experts. One is the expert who may not know that they're making that leap of logic, may just not have enough experience to realize that they are making inferences that are not really data driven. And of course, then there are the type of experts who are hired for a particular point of view and are making those leaps of logic without knowing that it is a leap, but that is what they are hired to do and are willing to perhaps stretch it a little bit. I would say for the most part, that tends to be ineffective when they're actually before a jury, but you don't, if you are a prosecutor, you don't want to get to that point. You want to be sure that you are looking and for any sort of vulnerabilities and that there aren't those leaps in logic, because you don't want to put on a case that is not fully sufficient. It is, it's unethical, of course, but it also is, can be devastating and especially when you perhaps can fill in those holes. So I think when you are the attorney, you need to make sure that you are aware of where those inferences are being made and how to challenge that and fill in those gaps when you need to.
Great, thank you. There's a whole nother scenario with another rich set of facts that we want to explore. But before doing that, Shelley, have there been any one or two questions maybe that we want to pose to the panel?
Sure. I'm just going to do one clarification and then we'll get into a substantive question, because there were a lot of questions around the idea of a vulnerable adult. And I think Michelle can address this pretty quickly, but some people are commenting that in their state, of course, they would have to first find that this person was a vulnerable adult. And I think it speaks to what Michelle was saying in the beginning, but do you want to just comment on that, Michelle?
Sure, for APS purposes, absolutely, Shelley. That would be what our intake staff would have to do, is determine whether or not the person meets the definition of vulnerable in the state of North Dakota, so they meet that definition. Plus, they're also experiencing abuse, neglect, or exploitation, and then that defines whether or not it's screened in or out, as I was talking about earlier.
And it really differs by state, and that's where you
does.
get into all these comments. The other really large area that we're hearing about is undue influence, not surprisingly. And there are many, many questions around that. I'm just going to choose one because I think this really is, it fits with our theme from yesterday as well. But what if Mr. McKinney is cognitively intact, but is being unduly influenced? So I guess the question there is really, can Randy talk about the distinction between, and Candace also, anybody, the distinction between simply that somebody can be unduly influenced and be cognitively intact?
I'll quickly speak to Florida law. And I think this is a legal question in some ways, but Florida law does explicitly acknowledge that someone can be unduly influenced without an underlying impairment. From my perspective, as a non-attorney, I think an undue influence claim with the presence of some kind of impairment is a much stronger claim. But I've offered my 2 cents, and I'll let the attorney speak.
So I think it varies. Again, based on your comment, Randy, I can also add that Colorado law has a specific statute involving elder exploitation, and it has various means in which this can be committed, and undue influence is included as one of those. So for our purposes, we would prosecute this even if we did not have a report from Randy that said there was impairment. We probably, if we got the case developed well enough, we could prosecute it based on undue influence. I would say 90% of the exploitation cases that we file involve a blend of undue influence and deception. We have intimidation and harassment as other methods, but those are the two most prevailing methods.
Candace, did you want to add anything, or?
Just a quick comment. Both speakers are correct. There are only about a half dozen states that specifically include undue influence in the criminal statutes. So in the majority of states in the US, we can't specifically prosecute someone for undue influence. But when we look at the tactics that are involved and the behaviors of the perpetrator, what we often find is there may be deception, there are false promises made, there's information that is denied, there's stuff going on sort of behind the curtain. And it is getting to that conduct that may form the basis for a theft charge based on false pretenses or deception. If there's a power of attorney that was obtained, it may be in a crime of embezzlement or something like that. So undue influence, shorthand, generally not stated in criminal statutes, but it may still be the basis for how you prove a different kind of crime, usually a theft crime.
Thanks.
Okay. We could probably go on with this scenario for another 3 or 4 hours, but there's another one we want to cover. So why don't we shift gears to our second fact scenario? This one involves caregiver neglect. Mrs. Peach is an 87-year-old widow who lives with her son, Bruce, in a single-wide manufactured home on land owned by a distant relative. The distant relative allowed Mrs. Peach and her son to situate their home on their property in a rural area 11 years ago when Mr. Peach passed away. Due to a stroke 5 years ago, Mrs. Peach's left side is paralyzed. She needs considerable assistance with most of her ADLs and IADLs. Bruce, the son, had a difficult time in school and dropped out in 10th grade. He's tried to live on his own occasionally, but has always returned home, in part because he's incapable of holding a job. He seems to have some mental health issues and uses drugs, although it's unclear whether Bruce is a person addicted to drugs. The 3 other children are independent and live outside of the state in which Mrs. Peach and Bruce reside. The 3 older children rarely visit their mother, although they send gifts, and are estranged from their younger brother, who they claim is their mother's favorite. The other children perceive Mrs. Peach as a domineering and demanding mother, and Bruce is too differential to his mother. Bruce has been the sole caretaker of his mother for the past 5 years. A couple of years ago, a neighbor who lives about 2 miles away thought Mrs. Peach looked to be in poor condition. The neighbor wasn't sure exactly what was going on, but she doesn't know Mrs. Peach well, but decided to call APS because she was concerned about whether Bruce could care for his mother given her stroke. APS visited Mrs. Peach. Mrs. Peach said she was okay, that her son Bruce took care of all her needs, and she didn't need APS looking in on her. So APS closed the case. Last month, Mrs. Peach's oldest child, Robert, paid his mother a visit when he was in a nearby city for a conference. He was shocked to find the condition of his mother in the home where she and Bruce lived. Mrs. Peach was lying in a bed in adult undergarments that were saturated, overflowing, and stuck to her body. The smell in the room was putrid. She didn't recognize her son, Robert. It was later learned Mrs. Peach had stage 2 pressure ulcers. The home itself was in disrepair. There was no electricity or running water. There was only a little bit of food in the home. They did have a car, so Bruce could drive to town and purchase goods. When Robert asked his brother about his mother's condition, Bruce said his mom wanted this. Bruce asked his mom if she wanted some help, but she said she did not. She didn't want to go to a doctor. She was afraid someone would take her away. Bruce claimed adamantly he was respecting his mother's wishes, adding, "She's my mom. I'm the one taking care of her." Robert left the home and immediately called 911 as soon as he reached an area with cell service. EMTs arrived and took Mrs. Peach to the hospital, and the hospital reported the incident to APS. Here we have a case of possible criminal neglect. At issue again is the question of consent. Did Mrs. Peach have the capacity to consent to refuse basic care, medical treatment, and other life-sustaining services, supposedly offered by her son, Bruce? In addition, the addition of family dynamics increases the complexity of this case, but it's similar in many ways to the financial exploitation case. So let's sort of dissect this one. Michelle, you first again. Upon receiving this complaint, what would you do? What would APS's first steps be?
Sure. So I think with all of what you've said, we'd want to review that past report and find out what was happening there, what was that report about, and then again, work to gather that collateral information from doctors. In this case too, I might also want to check with law enforcement if there's any records, if they can share with me if there's any records that exist there on their side to say if they've been out to the home with concerns prior. And then maybe determine based on the report if, have a discussion, should law enforcement come out with the APS worker on that initial visit, not only to help, hear the story, both of us at the same time with our different perspectives on that, the situation, hearing it at the same time, but also in case of danger, not just the worker's danger, but also Mrs. Peach. And we want to be cognizant of that. And so then I think upon arrival at the home, we'd want to try to speak with Mrs. Peach alone if we can to gather information from her, but we also want to take a really good look at the environment and her physical condition with her permission, of course, and then try to build that rapport with her And just, again, note all of the abilities that she has, her body condition, and again, the environment that we're walking into.
Okay. Given the facts as I sort of read them, would diminished capacity come up at all in your mind? Would that be something that jumps out at you, or would there have to be something else that triggered your interest or potential interest in pursuing whether or not diminished capacity assessment might be necessary? A decisional capacity assessment might be necessary, sorry.
Sure. No, I think that's, knowing the facts of the case, that might be something that we want to try to focus on as we work with her. Not, do we have to jump right into a test? No, but maybe we can look at some of that as we're having that, just that conversation back and forth with her and building that rapport, and try to gather some of that to inform maybe that next step to maybe look to doing a tool. I think, though, is that our primary concern when we go out to that home, if we find her, as described with the urine and the feces, that may not be what our primary concern is, right? We may want to focus on getting her assistance first. So calling 911, asking for the EMTs to respond, or law enforcement if they're not already with us, and then thinking about those health concerns first, because that should be a priority. Like, her safety and her well-being should be priority over finding decision-making capacity at that initial visit.
Michelle, do you have a MDT where you work?
Yes, actually, North Dakota has a couple in our state, and we're very grateful for that. We were just talking about the benefits of having an MDT, bringing everyone to the table, discussing cases openly, and then really working together to talk about what next steps should each entity, if appropriate, take in these matters to best help Mrs. Peach or individuals like her.
And would there be someone in the MDT who would be the one who would typically have an eye on, or keep an eye on, whether or not it's a situation where some sort of assessment would be appropriate or necessary or warranted?
I think, kind of as the setup is right now, if we were the first, APS was the first person to respond and saw that, we might be the one responsible to kind of help do that next step, at least the basic, cognitive screening tool that we talked about earlier, and then maybe making a referral to, for further testing once she's stable and her health is kind of addressed first. Yeah.
Great, thank you. So Skip, not everyone is familiar with criminal neglect. Could you talk a little bit about that? What are the elements of criminal neglect, and what would be the defense to such a charge?
Well, criminal neglect is acting in a reckless manner where there's risk of death or great bodily injury, and coupled with a reasonable person knowing that acting in that manner would create such a risk. So we need to have an elder or dependent adult. We need to be able to provide that as one of the elements. And then, is this a self-neglect case, or what is the agreement? Is there criminal neglect here? What was the expectation? What was the agreement? What was going on before, historically, throughout this relationship? Because it's been a lifelong relationship, often probably codependent, but it sounds like Bruce is in fact, reasonably taking his medicines as he's supposed to be. He's reasonably compliant with his meds. So, and that's where we're going to have to peel that back. What's the agreement? Is this self-neglect? And now she doesn't have the capacity. Does he have a duty to provide a higher level of care to his mother?
So again, I asked Michelle this same question. For you, given these facts, at first blush, would Mrs. Peach's capacity be an issue for you? Does it jump out at you as a question, or would it also be like Michelle, where as the facts develop, you'll see whether or not it comes out? Like, is there anything about the fact scenario as laid out that screams a potential capacity issue is at play?
Absolutely. Capacity seems to be at play here. And I'd like to know what the history is, what was going on before. Is there you know, at some point, did he just fall down on the care that was being provided? Or was he never providing care and she was just doing the best she could? And of course, that's the defense to this. He's just doing the best he can because he has this mental illness. But, you know, and that's again where that investigation is going to take some time, and you're really going to have to peel that onion back to see all of the layers of this relationship and what has gone on, and at what point did he, if he did, I'm sure he did, notice that there was a capacity issue, and does he have that duty to step up the care he's providing or get her help to provide that care, and what that agreement was.
Great. Thank you, Skip. Jane, shifting to you. Now, Skip has done additional investigation, as he mentioned, looking into peeling away the different layers of the onion and getting more stuff. What do you see? This lands on your desk. Skip comes to you, pitches the case. Like, what are you thinking? What are you asking? What else do you want him to look into?
So we see so many neglect cases, and some of those do result in misdemeanor or felony charges. So I guess the first thing I really want to know is I really want to get a sense of how severe the neglect was. And so I'd like to know more about how she's doing in the hospital right now. It's clear that she was expressing wish that she didn't want to see a doctor right at the moment that Robert visited. So she was certainly voicing her wishes at that point, although she may not be able to say much at the hospital. I don't know what her condition is. So I'd want to know, is there a serious bodily injury form? I guess we also have a multidisciplinary team, and if you're asking about what can we draw on, what resources can we draw on, I would be asking our geriatrician if she was available to go and do a consult for elder abuse on Mrs. Peach, and really exclude the possibility that there was any deliberate injury to her, and just find out what we've got, because the most serious and egregious cases that we receive that involve neglect generally would involve a really, really significantly impaired victim and some really heinous situation that they're in. So I'd want to know if Skip has interviewed Bruce in detail as yet, and what he said. Did he indeed put forward that he was just doing his best and he was following his mom's wishes, which I think that's likely to be the case, and the family dynamic does make this a more complex case. I'd still want to know, are we gathering all the other evidence that we would need to show this omission, because we'd be trying to prove an omission, and in our state, and obviously everyone would be checking their own state statutes, but we'd have to show a gross deviation from the normal standard of care for a caregiver. I would also be encouraging Skip to really follow up and find out details of the income of mother and son, because so often these neglect cases are associated with financial exploitation cases where the son maybe hasn't worked for years, he's living with her, he's getting her social security income, and he's spending that. For instance, a case that we dealt with recently, he's spending it almost exclusively on liquor. So the neglect may have a financial motive as its basis, and that's really what I'd want followed up. So the two issues would be geriatrician to consult if we could, and follow up on whether there's anything on the financial side.
Okay, let's go to that more egregious type case regarding capacity. Let's assume that Mrs. Peach is in a hospital, barely communicative and hanging on for life. Bruce is claiming that he's continuing to claim that he's only following his mother's wishes. She didn't want anyone coming to her home, and she didn't want to go to a doctor. Bruce says he offered on many occasions, as it was upsetting to see his mother in pain, but he was just doing what she wanted, and that Bruce said his mom didn't want him to help her change her undergarments, because that would just be weird. Two things. And so in this situation, we need to find evidence that Bruce had a duty to care and that in fact you offered to help. So Randy, what are you thinking as a clinician on the MDT in this situation?
Yeah, this is an interesting case. I think there's a few points. This woman was so impaired that there was a decision to hospitalize her. And so I'm wondering what her current functioning is as it represents past functioning. So there could be reasons to hold, if I'm asked to evaluate her, there might be reasons to hold off on the evaluation. Or alternatively, I could make an attempt to evaluate her now with the understanding that this might not reflect her functioning 2 months prior or 6 weeks prior, right? Some of these impairments are more what I would call dynamic, and they can be acute. Particularly when it comes to mental status, that can come and go depending on what the underlying cause is, right? So I'd have to think long and hard about the value of making an effort to assess her while she's hospitalized. There could be some benefits from that. But if I did that, for sure, if I'm seeing considerable impairment, assuming if during the course of the hospitalization, her mental status clears in some meaningful way, I think I have to reassess her to see what her mental status could have conceivably been like in the weeks or months before she came to the attention of Adult Protective Services and the hospital. And this all, of course, presupposes someone who's capable of participating in an evaluation, and if capable, is willing.
Great. Candy, as an instructor, what should we be looking for here? Like, what do we train on in terms of criminal neglect, and what would you add?
Well, I'm going to just reinforce what a lot has already been said. So I'm not going to repeat it, except to say we would include a lot of these same points in any training we would do on neglect. Like Randy, one of the questions I had is her current condition one of delirium, that it was recent onset, and it's something that can be treated without diminishing the extent of her pressure ulcers. Stage 2 pressure ulcers can develop relatively soon. It's not months and months, where we know that she's been lying in her own waste for a period of great length, so skin's broken down. We don't have all of that information. So there's reason to question, is this a temporary change of cognition, or is it something that represents a long-term pattern? I think there are some other aspects of this, and as I've watched some of the comments in the chat, pieces of this have also emerged. I'd like to know the victim's history, Mrs. Peach's history of seeking help in medical care prior to now. Has she always taken very good care of herself, even after her stroke? Was she always highly attentive, maintained appointments? And is this a change in that pattern, or is this a long-standing pattern? While we're talking about history, I'd like to know the history of relationships between mother and son, because I think it's important to think about, has it been a long-standing toxic environment? Has mom always been highly dominating and domineering, and her son very much more subservient, so that countering his mother's desires is really quite unthinkable? What are some of the cultural values in the home, including the view of caregiving, especially intimate caregiving by a person of the opposite gender or by a son on a mother, that sort of thing? What are the local services, and have they been offered? Is there awareness that services are available? Is the suspect living in the same circumstances as mom is? Because sometimes we see situations where, yeah, they're under the same roof, but they're in very different. The son is doing, or the perpetrator is doing very well, living quite nicely, and mom is living in really dire circumstances. I also would want to know more about Bruce. are suspect and what his abilities are to provide care. There are suggestions that he may have his own underlying issues suggested by his short education and other things that suggest he may not be high functioning. I really think we need to explore is he even capable of providing care, and what is the level of care he's able to understand. Has anyone ever provided him with information on how to meet his mother's care? And so I think those would be some of the additional facts that would be important to think about and for a team to think about.
Great, thank you. Jane, I want to shift back to you again. You talked a little bit about the circumstance, you see many of these types of neglect cases. And I was wondering if you could talk a little bit more finally about when a case tips into the criminal neglect realm. I think you talked about some of those, but I hope you can elaborate because these are all around the country. These are so common. And in many jurisdictions, I think prosecutors are loath to pursue these cases just because it's messy. There are lots of different complicating factors. And I understand it's a continuum, but for you, like, what do you look for? What are those factors that really tip it into a situation where you feel like you have to pursue it criminally?
So I think that we always have to assess the strength of our evidence, Andy. And, we may have some cases where the situation's egregious, but the investigation just doesn't produce sufficient evidence for us to feel comfortable going forward. And I don't mean to be vague, but I think that it's finding a balance between the vulnerability of that victim and the circumstances of the neglect. And we do see very bad cases. So, for instance, cases involving gangrene, for instance, that obviously the caregiver would have been aware of and was failing to get any help for a significant period of time. Cases where our geriatrician tells us this victim was really suffering. Often when there's an issue over continence, as we know, we'll see a victim being admitted to the hospital and they've got extreme malnutrition. They're dehydrated because it's less in, less out for the caregiver. And so when our geriatrician says this person really had an extended period where they would have been in pain and would have been going through a very awful situation, then I think we staff it. We work with our partners on the MDT to see how what the case looks like, and it's in those cases where we find that balance just makes us feel, yes, there are many neglectful situations, but this is a neglectful case that has risen to that criminal level because of all those different aspects. And I think the input from different disciplines is really critical to making good decisions on those cases.
Great, thank you. So OVC, Office of Victims of Crime, has funded about 23 different MDTs with the stipulation that they include a professional qualified to conduct diminished capacity assessments, signaling the importance of having access to such a professional. Randy, what is the advantage of having you serve on an MDT?
Well, let me just say this, Andy, that if I was on a multidisciplinary team with the professionals in this Brady Bunch square of videos here, it'd be the multidisciplinary dream team, not the multidisciplinary team. But I would like to think that what I would bring would be expertise with respect to having a well-developed understanding of what we might reasonably expect someone who's aging normally to kind of exhibit and display, to be able to identify indicators of underlying impairment and describe how any emotional, behavioral, or cognitive impairments might go to compromising decision-making capacities or judgment. I was looking at some of the chat messages at one point, which are just fascinating. And someone mentioned, I think the gist of their comment was, well, how might assuming, beyond cognitive impairment. But, you talk about emotional, behavioral, and cognitive impairments. How might non-cognitive impairments compromise decision-making capacity? Well, I would say emotional impairments, right? I think some impairments of mood can compromise people's judgment and decision-making with respect to how they're making sense of what's going on around them and how they're valuing things. That would be an example of how we can get impaired decision-making, not simply as a function of impaired cognitive impairments.
Okay. So in our fact scenario, Mrs. Peach declined to have an assessment done. If she were to agree to some sort of capacity assessment, how would you conduct that assessment and what would you look for?
I have to acknowledge some parochialism here. I started out by saying I'm a psychologist by training, and I would encourage any healthcare professional on the call to look for direction from his or her own code of ethics, because they will vary dramatically. But the code of ethics for psychologists do allow psychologists in some cases to offer opinions about persons they have not examined, people like Mrs. Peach, if, number one, we make a good faith effort to examine the person, and two, if we believe we have a reasonable factual basis to form opinions about their functioning. So even if Mrs. Peach refuses to participate with me, I will make an attempt to form opinions about her functioning, looking at collateral records and collateral informants. I think those records and those informants, that's sort of obvious from the scenario, what they would potentially be. After I've gathered that data, I have to make a decision as to whether I believe I have an adequate factual basis to offer commentary about Ms. Peach and her functioning and her decision making, given the database that I have. And you don't know whether you have an adequate factual basis until you review all the collateral data sources, which of course are all the data sources other than what Ms. Peach is telling you because she's refused to participate. Whether the same goes for psychiatrists, whether the same goes for non-psychiatric physicians, whether the same goes for social workers, whether their code of ethics allow them to do that. Unfortunately, I can't answer that, but I'm sure those professionals would know for themselves.
Okay, great. Thank you, Randy. Judge Young, you obviously do not sit on an MDT, but you've been listening to the development of this case. It's now 9 months later, and the case is now before you as an allegation of criminal neglect. And the case hinges on Mrs. Peach's ability to consent to refuse proper care and treatment from her son, Bruce. Who is going to have to provide that testimony?
So I just want to say that I think this is a great example, hypothetical, since these are the kind of neglect cases that I remember seeing a lot of, and it really touches upon so many tricky issues because I don't think we can fail to acknowledge that the fear of going to a nursing home and have strangers take care of you can be very real, and that an elder may prefer to have substandard care by a family member than going to a nursing home. That is sort of an underlying theme of some of this. As well as we have the caregiver, Bruce, who's got his own issues, and exactly what those issues are or not, we don't entirely know. And I think the example also had that the mother was historically demanding and domineering. So meaning that, dissension by Bruce of insisting what to do is likely to be difficult with his own disabilities, plus sort of their historical relationship. So all of that is really pretty common, which doesn't mean that we should throw up our hands and say there's nothing that we can do, because there are lots of things that we can do that everybody else has touched upon. It probably means, you have to have neglect plus. You need to have some type of capacity evaluation, or potentially, if Mrs. Peach has been in the hospital for a long period of time, her care providers in the hospital may be able to provide enough of that context to give some sort of inferences with it. So if she enters the hospital and she is quite delusional, you may be able to have some type of medical expert testimony as to what that means. Now, Candace pointed out that stage 2 pressure ulcers are not necessarily, well, they're not long-standing, they're not necessarily really severe, and depending on where they're at, they may not have even been noticed by Bruce. So you've got to kind of explore that particular issue with it. If they're stage 4, where they're down to the bone, that can be a very, very different issue with it. But again, the location of it is going to be really important, whether or not that's on somebody's heel because they've been stationary lying on their back for weeks on end, or whether or not it's on, you know, her hip. And her, you know, he doesn't change her undergarments very regularly, and so may not see that in the same way. That can also be really important to know. Talking about the living situation of the two people, whether or not he's living in cleanliness and she's living in filth are really important. Although I would posit that that seems to be a rarer situation, that if the mother is living in this kind of conditions, chances are the whole house is in disrepair and Bruce is not living in relative cleanliness. I've seen that, but that is a rarer situation. But what is often common is that there is this sort of side thing that Bruce may have longstanding mental health issues. We have this subtext of perhaps drug issues. So he's taking mom's Social Security and spending it all on drugs and using none of it for care. That can be really important to know. We've also talked about the history of whether or not she's been pretty scrupulous about her medical care, and then all of a sudden at one point it completely drops off. That can be really important to know. And it can be really important to know that Bruce has accompanied her to any of these medical appointments and knows about what her needs are with it. But I would also suggest that I think that scenario where she's been scrupulous about her medical care and then it has sort of fallen off is pretty rare. There's usually sort of this gradual decline and maybe years of no medical care, which could be due to a cognitive decline, or to know exactly when that started, and or sort of an ambivalence about medical care to begin with. So I think there's a variety of different ways to sort of figure this out, but you absolutely have to show that her consent to living like this is compromised in some way. And if she's refusing to do that, which is what this hypothetical has, then there's a variety of other ways in which you can potentially show it. But I can think of several cases where we just didn't have enough information. You know, Bruce and Mrs. Peach lived in this sort of black box, and the other siblings were not present and were not there to see what was going on. And you just have this real dearth of information that is, it's really hard. And I just really want to emphasize that it does not mean that you shouldn't figure out what you've got. There's neighbors, there's a whole variety of ways in which you can try and pierce that black box, but not to get too, too worried about or think you're doing a poor job if you see that, you know, it's Bruce and his mom, and that's all that you've got for years potentially.
Thank you. I think that's a critical point to make, given the fact that that is likely to be a significant number of these cases that are out there. And so people have to be creative. People have to think broadly and creatively about sort of how to piece together a case that they can be pursued criminally if necessary. Before we give you guys a chance to sort of share your views, Shelley, were there any questions in particular in the chat box you wanted to pose to the panel?
Yeah, sure. We go to the top here. Let me first say that we had a nice, strong endorsement of MDTs, which I was quite happy to see. But this question builds on the clinicians panel yesterday, so I wanted to get to this. When you obtain a capacity assessment and the victim's capacity is central to your case, can you give some examples of really helpful assessments and really poor assessments and what those might look like, or how you would distinguish between the two? I guess probably our attorneys, or maybe Randy.
Well, I have.
You guys, as an investigator, I'll jump in real quick. getting a capacity assessment is extremely difficult in our setting. Physicians do not want to do it. We have a case that we're investigating right now where our gentleman lacks capacity. I'm not a doctor, but I'm a cop, and I've got a little bit of experience in this. He was admitted to the hospital. He's been in restraints for 3 weeks, and we could not get a doctor to administer a capacity declaration for a public guardian conservatorship or even a probate conservatorship by family members for this gentleman. Yesterday, we were told that there's a nurse practitioner that's willing to do it, but it's very hard to get a capacity declaration done because physicians do not want to stick themselves out there on that line.
Does anybody else want to comment on that? Any of the other panelists?
I'll say this, the judge and the attorneys can respond to what they think about this as the person who provides the report or provides the testimony and then may go into court. What I advocate strongly for is that all opinions be expert opinions. That is, any opinions that the expert witness offers are truly a function of specialized knowledge, training, or experience, and that we not dress non-expert opinions up as expert opinions, and that a factual basis for all opinions offered be offered so that the consumer of the opinion, the judge or the jury, and the attorneys for that matter, so that they can appreciate the reasoning and the logic that the expert used, and then they can decide whether they're comfortable with it and whether they want to adopt the proffered opinion in return. That all, I think, all goes under the general principle of transparency when it comes to testifying. Being very clear about what you did, what you learned, the opinions you formed, and the logic underlying them with the associated reason.
I think to what you were saying, Randy, about vetting experts, hopefully you're going to get a good report because you've done a lot of the groundwork before. You've had a meeting or a conversation with your expert. If you don't know them well, you've got referrals from other people you've worked with who know this individual, and you've hashed out exactly what you're trying to get to legally. So you've given any definitions that you need, and you've set hopefully done a lot of work before you get the report to set it up to be successful, rather than just kind of punting it and hoping it all works out.
In North Dakota, we've sometimes experienced what Skip was talking about too, but I appreciate what Randy was saying. Like, it's really helpful to have the results of the testing and the statement of the facts, and then kind of like here's what I see, as a result of this testing. Whether or not you can say clearly enough that the capacity is lacking, it's really helpful to us, but we have experienced the same thing where doctors are not really super willing to put their name out there and say this person lacks capacity to do X, Y, Z, and that can hinder a case if you're looking for forward movement.
Shelley, was there any other piercing?
I was going to say, do you have time for one more?
Let's do one more. That'd be great.
Okay, good, because this really is an issue that comes up a lot, and it's more for our clinicians, but it's just anybody trying to understand capacity assessments. And there were several questions around the transitory nature sometimes of capacity that can be influenced by delirium or UTI. A number of people were commenting on the UTI issue. And here's the comment that I want to read and then let people respond. I had a GAL testify in court that no one ever regains capacity after they go to a nursing facility. She testified that even if an untreated UTI landed them in the facility, she was successfully resolved, the person was incapacitated. So I thought it'd be really important for us to clarify this, this notion. I guess that's Randy to begin with.
Well, I'll as a psychologist, I'll defer to the medical professionals on this, but I'm shocked by such a claim. Number one, I'm shocked that you said it was a GAL in Florida. I can't speak for other
I don't know where.
A GAL in Florida would be a non-professional, or certainly not necessarily a healthcare professional. So I'm surprised that that person might be offering opinions for which he or she is not qualified to offer. And I think it falls on to the responsibility of the attorneys to kind of prevent that kind of testimony from coming in. But I'm surprised by the account. Let's say that. But I'm willing to hear from my medical brothers and sisters.
Okay, I think we'll end there. Thank you.
So with that, I wanted to give everyone an opportunity to talk a little bit. Obviously, you guys know, we chose this hypothetical intentionally given its complexities and given the fact that, as Paige Ulrey, who many of you know, would describe this as a case that dies on the vine all too often. I was wondering if each one of you could talk a little bit about what more we all can do, or those in your profession, could help prevent these cases from dying in the vine. Are there court reforms? Are there training reforms? Like, what can we do to make sure these cases get the attention that they need and are prosecuted where appropriate? Maybe we'll go in the same order that we've been doing throughout the panel. Michelle, maybe starting with you.
Sure. I certainly think education would be helpful. But I think also if we're thinking about like MDTs, really working together to maybe find resolutions for these cases and talking about next steps, best next steps. I also wanted to just comment on, I saw a lot of comments on fear, that she would fear going to a nursing home, but I also think the people like Mrs. Peach also experience like the guilt and the shame and that blame game for themselves when they're being victimized by a loved one or somebody that they have, trusted to provide their care. But I think, in my personal opinion, I think an MDT and using your resources and working together, plus educating each other on your roles and what you can and cannot do, could take a case further. That's my hope.
Great, thank you. Skip, you?
I think communication and collaboration is the key in this. When they say it takes a whole village, it really does. I think that you need to find your stakeholders and those people that can help you and assist you throughout, your investigation. My focus, of course, is an investigation, but it's also to provide some sense of a quality of life for our victims. And so I think communication, collaboration, and also educating people. I have had doctors who have called me and said, what do I do in this situation? Because they don't, they've been a general prac and they've been treating their patient for years and years, and they're really not specialized in geriatric medicine, and they don't know what to do in a case like this. And then oftentimes they start to see that influence or whatever inside their own practice with a son or a daughter who's bringing their mother, father in and kind of influencing that even in there. So I think that the biggest thing here is working together and finding out, all of the different gears in play, what's really going to make the whole wheel turn, and what other discipline can offer assistance to you, and learn from it.
Great, thank you, Skip. Jane, your thoughts?
So I agree with all of Michelle and Skip's comments here, but just to add, I guess, to this kind of wish list, a lot of these cases originate in hospitals when someone's taken EMS and patrol attend, the person has to go off to hospital immediately. We encourage our officers and detectives to start working on a warrant for whatever is going on at the home. But I think that educating the more in the medical field definitely produces an increase in referrals in these cases. So it's not long that we've had a jurisdiction, but that has fostered and encouraged education in the medical field that's resulting in more referrals of these cases. And then I think, you know, to all the comments we've had about the difficulties of getting folks to get involved as experts, as prosecutors, you know, we want to work efficiently with folks, but I think we definitely spend a lot of our time chasing people down. So perhaps one would encourage the other. Perhaps if we had more people aware of the issues and educated, we'd have more people willing to back us up and support us when we really feel like a case should go forward.
Great, thank you, Jane. Candace?
Again, I share the same perspectives as the others who've already spoken. I think what I would add, in addition to the value of MDTs in cases like these, is we still need to see these cases more holistically. Whether a case is prosecuted or not, there is a situation that may need services and may need the joint efforts of everyone here and others. And the MDT is the most effective way to accomplish that. I think we need ongoing professional training. I've seen some notes about we have training. We did it 5 years ago. We did it a year ago. One round of training is good, but it isn't going to solve the problem of confusion and lack of information. And then finally, we do need a bigger cadre of qualified evaluators to provide expert opinions on decision-making and other capacity, particularly for criminal justice situations. But that requires both training and funding. Thank you.
Thank you, Candace. Maybe I'll go with Randy before we end with Judge Young. Randy, any thoughts?
Well, I'll just quickly say that when you speak after all those who've spoken before me, I really don't have anything, I think, to add, but would endorse everything I've heard by those who spoke previously.
Well put. Thank you, Randy. And Judge Young?
Well, I just want to encourage people who are at the symposium who maybe aren't part of an MDT already to not think about it. It has to be this formal multidisciplinary team, but that you can start now by reaching out and creating relationships with experts or with law enforcement or with first responders or banks, getting to know the people who may have the first sort of either contact with victims or whether or not people who maybe can help you evaluate what kind of case you have can be really, really helpful. I strongly believe that the prosecutors in this system often are the ones who are driving the car. And so if prosecutors are willing to take cases in the right circumstances, then often some of the other people like detectives maybe who are a little more reluctant will follow along. So talking to your homicide detectives or talking to your fraud detectives or talking to the sergeants of the first responders who go out or the supervisors of paramedics or people at the hospital, what you're looking for, and then making sure that it's public when you do find the right cases and you are proceeding, what you have done can really help all of these other things fall in line. So I would really encourage people to reach out now to develop, even if it's not a formal network, your sort of informal network, and then letting it, talking to people about what it is that you're doing. So people are willing to every time take another step further rather than, you know, not refer it to law enforcement or not refer it to prosecutors or not seek a capacity evaluation or not know where to go for any of that.
Great. Thank you. I would agree with that completely. I'd also just make a small plug. On the Elder Justice website, there is a webpage that we have for our MDT Technical Advisory Center. Talitha Quinchaver, who works with the Elder Justice Initiative, is free to advise people who are interested in putting together some sort of team. And as Judge Young said, they don't have to form in a certain type of way. They have all shapes and sizes. The Elder Justice website actually has a map of all these different types of Elder Justice networks. And if you go on, you see the true diversity of these types of teams. But with that, I'd like to thank this phenomenal panel for an invigorating and wide-ranging discussion. I think we've all learned a lot and sort of realized how much more there is to be done on this topic. Before closing, I would just invite all of the audience members to stay on after a brief break for a participant discussion where we'll try to get more input from all of you. As I mentioned earlier on, this is the beginning of the discussion, and so this is an opportunity for you to share some of your thoughts on what more can be done on all of these important issues. So with that, we will take a brief break and resume at 3:25 Eastern. Thanks again for the panel, and we look forward to seeing you shortly.